Hello, welcome to another episode of Justice Now. I'm Joe Lewis, your host. Today we're going to be doing another educational show, which are always my favorites because it is always a positive thing when I get information out there to the viewing audience, especially those who are going through family court issues, so that you better understand the system that you in and be able to maneuver through that system efficiently. We're going to focus mainly on the history of the family court. And I know a lot of you who have been through that system and who have went through your struggles in that system wonder how that system came about. So we're going to start off with some of the history of the family court system. I'm going to go in through the first appointments of what we know down there as judicial hearing officers, which are called JHOs, the referees, and the magistrates, really focusing on the powers of the JHO and the referees, because a lot of times there's a lot of confusion in that particular area, not just for certain individuals who are going through family court issues, but for attorneys as well who find themselves representing lifelong clients, maybe from a civil issue or from a criminal issue. And that long lifetime client comes to get them to handle a family court issue. So an attorney who's not really familiar with the family court, who may be new to practicing law, this information could be pertinent to you as well. Like I say, I'm going to start off with some of the history first. As you know, the family court system was really structured to really work towards handling certain issues like divorce, custody and visitation, child support, or any domestic family issues. Was really structured in New York State in its efficient working form around, I would say, in the late 60s. In the mid-70s was when they noticed they was getting the overload of court cases. And to be able to effectively put time together towards each individual case, they created different courts to be able to handle these different situations. And because at one point there was one judge who was hearing divorce, visitation, and custody, child support issues, things of this nature was heard by one judge. So eventually they separated these specific issues to specific courts, and this is where they developed the aspect of having certain officers of the court hear these particular cases. And thus we have what we've got today, which is the judicial hearing officer, which hears family court cases of visitation and custody. They can hear also family offense cases, any cases involving orders of protections can be heard in front of these sort of judges as well. Then you have your referees, which hear cases on visitation and custody. They also can hear certain cases involving adoption proceedings. And you have your magistrates, which hears the cases that are specifically dealing with child support issues. So in the mid-70s is where the idea came up to appoint some of these special hearing officers because of the caseload that was growing in size in the family court system. So now you have your judges who hear cases, mainly Supreme Court judges who handle the divorces. You have your JHOs, your judicial hearing officers, who hear these cases in family court, such as visitation, custody, etc. You have your magistrates. Now these specific officers are being set up in the family court through legislation to be able to hear these certain cases. By the mid-1980s, these courts also was in full swing of how they would operate, exactly what type of cases they would hear, etc. Now, the family court is one of the most largest part of our court systems in the state. And when I say largest, I mean by the cases that are filed in the family court are much larger than the cases that you will see filed in criminal court, civil court, etc. In family court, I think in Monroe County, I think that there were between 26,000 and 28,000 cases filed for the year of, I would say, 2013 in family court. And statewide, there were about 750,000 cases filed statewide in family court. So family court has a very large caseload. I would say around estimated 5,000 of these cases winded up in the courts of the referees, which in our county it would be referee Polito, and then you have referee Gordon, and they got maybe about 5,500 cases themselves in their courts. And so what you want to know is when you go into these courts that these certain officers have specific powers and duties. The judges who handle these cases have exclusive power. And when I say exclusive jurisdiction, I mean they have the power to hear any cases that have to deal with a family court issue. Those will be your Supreme Court judges, some of them your Monroe County Court judges. Now, when you get to the referees and the judicial hearing officers, it's a whole different story with these individuals. They have limited power. Any power and authority that is given to the judicial hearing officer or a referee can only be given by what is called a referee stipulation. Okay, referee stipulation is a form that is given to you when you are arraigned in a court that is governed by a referee or a judicial hearing officer. Now, like I said, these individuals have an exclusive power, and we're going to get into that power momentarily. And any information that I give you, trust me, I will post up any websites or any resources of information that I use will be posted up as well. Any case law that you hear me cite, I'll post that up as well. Now, to get into this power that's given to the judicial hearing officers and the referees, you have to be aware of this because you have the right as a petitioner or respondent in that court to give them the power to hear and report or hear and determine the outcome of your case. And when I say by hear and report is a phrase that gives the referee or a judicial hearing officer the limited power to only hear your case, which means they can't make decisions in your case at all. They can only take in the information that you give them, and then they have to submit all of their findings to a judge in that case. And you have also the right and the power to contest the findings that the referee or the judicial hearing officer submits to the judge. And the reason why I'm telling you this is because the bulk of the family court load is usually pro se litigants. Pro se litigants meaning individuals such as you and I, who may find ourselves without the ability to be able to afford an attorney. Therefore, we have to represent ourselves in court. So as a pro se litigant, if you find yourself in a situation, or as an attorney, you have the power to contest all of the findings that the referee submits to the judge. And so make sure that you request from that referee or judicial hearing officer what those findings are. But going back to the referee stipulation, this is what must happen when you are arraigned in front of a judicial hearing officer or if I won't say arraigned, I would say first appearance in front of a judicial hearing officer or a referee. Once you go into that courtroom, the referee is going to basically, or judicial hearing officer, is going to read the number of the docket of the case. They're going to make sure that both parties are present. They're going to ask you, would you like the right to an attorney? Then they're going to basically hand you a slip of paper, which is called a referee stipulation. The job of the referee, when he or she submits you that referee stipulation, is this: they must make sure that you are in full understanding of what that stipulation entails, so that when you sign it, you have a clear understanding of what you just signed. So what they have to say to you is basically this. These are the words you want to hear somewhat in this fashion come out the referee or the judicial hearing officer's mouth. And those words are simply this: once you get that stipulation passed to you, what I have given you is called a referee stipulation. What that does, if you choose to sign it, is give me the power and the authority to make all decisions in your case, including the final determination in this case. If you choose not to sign it, which is your choice, that is your legal choice, which is your choice, what will then happen is now I will only have the power to hear and report my findings of all the information of what I hear, testimony, documentation, whatever, to a judge, and thus the judge makes the decision. Do I have your permission to hear and determine this case? If your response is yes, then you sign the referee stipulation, giving them that power. If you exercise your right, which is your legal right, to say no, then you do not sign the referee stipulation, and therefore all of your findings in that case will then be submitted to a judge who will make the final decisions in the case. Now, in my years of experience of being a court advocate in the family court, I am seeing a lot of issues arise in this area of law in the family court system, where there are individuals who are not being told their rights involving the referee stipulations when they go in front of a referee or a judicial hearing officer. So make sure you understand that you do have the right to sign or not to sign. Make sure that is explained to you, and make sure you understand whether you are in front of a judicial hearing officer or a referee, so that you can fully exercise your rights. One of the things that I'm hearing is that there's no statement at all being made to the individual signing the referee stipulation or the stipulation period. The paper is just being slid in front of the individual. The judge or the referee is just asking them to sign it and not letting this individual know that they have a right to sign or not to sign. I'm also hearing that certain individuals have been bullied into signing these stipulations by some of the deputies in these courts. The deputy is sliding the individual the paper. They're asking the individual to sign it. And the individual is saying, no, I don't want to sign that. And they're telling them, yes, you have to sign it. Another thing that I'm hearing is I am hearing situations arise where, and matter of fact, not hearing, witnessed myself, situations where the referee have made statements like, nonchalant statements like, I'm giving you a referee stipulation, or he'll tell the deputy or she'll tell the deputy, give them the referee stipulation so they could sign it, so I can make the decisions in this case, and when you sign it, it gives me the right to do so. Not telling the individual that they have the right not to sign, but just saying simply, deputy, could you pass them the referee stipulation to the petitioner and the respondent so that they can sign it, and I can make the determination in this case, and signing that stipulation gives me the power to do so. Not basically telling them that they have a right not to sign it, and what happens if they decide to exercise that right not to sign it. So I see plenty of individuals who are in situations like this where they are very dissatisfied with the judicial hearing officer handling the case, very dissatisfied with the referee who is presiding over the case, and has been coerced to sign referee stipulations that they never should have signed, or the referee stipulation doesn't really have the authority and power that it should have because they did not fully disclose the rights to the individual not to sign and what those rights, if executed, would entail. The rule that governs this power that you have in the courts as a respondent or a petitioner is CPLR 2104. CPLR, which is the Civil Procedure and Law Rules, 2104 basically describes this power that you have to sign or not to sign the referee stipulation, and the referee being required by law to make sure that the referee does let you know your rights involved in this area. Now I'm going to read something to you here, and there's several CPLR rules that talks about the referee's responsibility, legal responsibility, to make sure that you understand this, or the judicial hearing officer as well has to make sure that you understand this before you actually sign this document. Now, here, I'm going to read this to you. And some of these things come from the McKinney's case law. Some of these things come from the CPLR rules themselves. A referee derives the authority from an order of reference by the court. See CPLR Rule 4311, which can only be made upon the consent of the parties except in limited circumstances. And I'm going to tell you what those limited circumstances are. The consent of the parties in an essential judicial predicate, see CPLR Rule 4317. You can also see the matter of Stewart versus Mosley, Ellison versus Ellison, McCormick versus McCormick, Wilder versus Wilder, and let's see what other one we have. Oh, McCormick versus Feeman. also as well. These are cases that, if you don't see them here, which some of them you will see, as I'm saying to you now, posted up. If not, in the credits, I'll post these cases up for you so you can go look them up for yourself. But the CPLR Rule 2104 definitely goes into the details of stipulating how the referee should go into getting the consent, which is basically called from the order of reference from the person sitting in front of them, which would be the petitioner or the respondent, in making sure that he has the power and authority to hear and determine or make decisions in your case. If you do not sign that referee stipulation, like I said, they don't have the power to hear and determine. Therefore, they will have to submit their findings to a judge, and you can contest those findings. And like I said, I'm seeing in a lot of situations where individuals are basically being coerced into signing those documents, and the referee or magistrate is hearing and making final judgments in these cases. So if you have ever signed any of these referee stipulations or judicial hearing officer stipulations, and you were not told fully, disclosed of the rights that you have not to sign, and you may be in a situation where they have made decisions in your case, and you feel the decisions may not have been adequate or wrong, then my advice is that you research the rules and regulations that I'm going to be posting up here for you, and maybe you need to file a complaint to the supervising judge, or maybe that may be the basis that you file your appeal on, is the fact that you are not told of your rights to sign that referee stipulation, or not, sign that referee stipulation. Like I said, the rules that really govern the power of referees and JHOs will be CPLR Rule 4311, CPLR Rule 4317, CPLR Rule 2104. These are the cases the CPLR rules that you want to look for in making sure that you understand what type of rights you have in that court. And like I said, if you did wind up signing any of these things, you want to make sure that you check the law and get the type of judicial relief from the court that you want, because if they did not make full disclosure to you and get your right to sign that referee stipulation, you want to make sure that they don't make those final decisions in your cases. And so, like I said, everything is going to be either posted up on the screen while I'm talking, or posted in the credits so that you can look this information up yourself. So it is important to know who you're in front of when you go into family court. You want to make sure you understand the power of the individuals who are adjudicating your cases, whether it is a judge, a judicial hearing officer, or a referee hearing your case as well. Now, magistrates, which are hearing officers in the child support court unit, really do not need the referee stipulation to be signed. Most of you who have been in front of magistrates probably know this, or have noticed that you've never been asked to sign any type of paperwork giving the magistrates the authority to hear your cases. They do have authority to hear child support matters. So what you really want to do is focus in on the referees and the JHOs in hearing your cases. And this is one of the reasons why I run the American Judicial Rights Organization, and we basically help individuals in maneuvering through that court system, because the court load that comes through the family court is enormous. I mean, it is enormous. And then the bulk of those cases are pro se litigants. And so that's where we come in helping you be able to understand these things in court, providing you with the proper materials and resources, if necessary, where you need to do self-representation, exactly how to use the tools in the library to look up the law, how it pertains to your case, giving you and helping you to understand the certain buzzwords in your case, which is what we call in the research profession, helping you to understand what these buzzwords are, using the materials in the law library to the best of your abilities, and being able to represent yourself efficiently. And one of the law libraries that I like to recommend is the one that's right over there on East Avenue in the 4th Division Appellate Court Building. That is a very good resource. The law library has great librarians in there. They'll show you everything, basically, as far as resource tools. They'll show you where everything is at. They have a great family law section down there, and they'll show you how to utilize, all the materials down there. And so, like I said, once again, this is why, the American Judicial Rights Organization steps up to help individuals maneuver through that court system, especially when it comes to these courts involving the referees and the JHOs in these courts, so that individuals know, who they're in front of and how much power and authority do this person have involving their case, and how much rights you have as well. Now, these JHOs and referees are appointed through legislative law, and they're also brought up on review. I believe it's every 2 to 3 years. They look at their caseload, how they handled their cases, and basically evaluate them for reappointment for the following year. And so one of the things that I want to do, when we run our organization, is to help you guys understand what type of court you're in, so that you can reduce some of the recidivism of you having to go back down to court basically for the same issues. And this is one thing I believe that's causing the court system to have such a humongous caseload, is that the way the court is ran, it is not really effectively ran to be able to help you maneuver through that court system and get the judicial relief you want, so that you don't wind up back down in that court. Most people who file petitions on the average within a year, 3 to 4 times a year for the same issue. Most of the clients that I get as a court advocate, this is something that I'm noticing, that when they submit their paperwork to me to look at, so that I could get an understanding of what are the issues involved in your case and why are these issues apparent in your situation. Individuals will come see me, they'll come to my office, and they'll bring a stack of paperwork as thick as what you see in my hand here, some of them thicker. and they'll set this paperwork down in front of me. I'll look at the case, the various cases that they've had, any transcripts, any appeals that they might have filed, any petitions, and I see issues reoccurring over and over and over and over and over again involving visitation and custody. And so our goal at the American Judicial Rights Organization is to help you understand how the court functions, where the powers are at, so that you could get the judicial relief that you're looking for, and sort of point you in the right direction of how to go about doing the research that you're going to have to do that helps you find the exact type of law that is pertinent to your specific legal issue, so that you can get the judicial relief that you want, so that you don't wind up going back to court 4 or 5 times for the same custody and visitation issue or child support issue. What we also do at the American Judicial Rights Organization is that we help you understand the relationship that must exist legally and ethically between you and your attorney. One of the problems that I'm seeing arising as well is that people don't, or ordinary citizens who go into that court system, do not have an understanding of what type of relationship they should have with their attorney and what type of duties by law the attorney has to perform for them. And so we help you understand that. And one of the things we do, make sure that you read on your own and study this stuff, is the model rules of professional conduct. The model rules of professional conduct go into the very detailed legal relationship that you should have with your attorney and the responsibility and obligation that the attorney has for you as well. That way, if you have a better understanding of what that is, you have a better understanding of what your attorney should do and not do. You're not under this sort of false information or false doctrine of what the attorney should be doing, which causes conflict all the time between the attorney and their client, unnecessary conflict. And it gives you a better understanding to the point where you are not operating under this false illusion, which would make you at times rate the performance of your attorney in the wrong way, which is another thing I see that happens. Individuals have this lack of understanding, and because of it, my attorney should have did this for me, my attorney didn't do that for me, and based off the model rules of professional conduct, the attorney shouldn't have really honestly did either one of those things, because it is really not the attorney's responsibility as far as the relationship that you have with the attorney and client. And so this is one thing we help you to understand as well. We also help you to understand what the true responsibilities of the judge is. Now, there's also out there what we call the canon rules for judges. Now, if you look up the canon rules online, you will see probably a small paragraph, maybe information that's about a page long that goes into each canon rule. There is 5 canon rules. Now, if you happen to go down to the law library on East Avenue or wherever the law library may be near you, or that you're able to go to, you will find out that these canon rules actually come in a volume. And I believe that there's 5 volumes to the canon rules. And they're in books called the McKinneys. And the McKinneys, as you'll find out, once you represent yourself pro se, are great resource books when you're doing your own research for your cases. The McKinney's is usually the books that you start at. But they will be 5 volumes of these canon rules for judges, depending on, like I said, what law library you in, what state you in. Some of these canon rules may be a lot longer, so they may consist of more than 5 volumes. Some of them may be shorter, depending on, what state you're in. But you want to understand what the duties of the judge are, and so that you are not looking at the judge's performance in a way that is based off of a false doctrine. Now, a lot of these false doctrine arise because, and I'm speaking to individuals who are doing pro se litigation for themselves and probably have been doing it for years. We all know that there is a prejudice and bias in the family court system. There's a prejudice and bias in certain courts towards fathers who want to be involved in their children's lives, and the court seems to have a nonchalant attitude to the rights of the father, or a attitude as if to say that the father doesn't have any rights at all. So we know that this exists in that court system. There are also mothers who are experiencing this same sort of prejudice and bias in that court system, where you have been made to feel that your rights are non-existent. And then there are grandparents who are basically made to feel that they have no rights or say so at all. And sad to say, the law is structured like that for grandparents, where grandparents really struggle in that court because there's very little rights down there for the grandparent. And you have experienced a lot of prejudice and bias. And so you have a lack of confidence in not just the judicial system, but the judicial officers that represent you down in that court system. And so this is why I'm giving you this information. Because the more you know, the more you can differentiate between what you may see as inadequate work based off of a false doctrine and what is actually, factually, legally the responsibilities of the officers in the court, be that if it's your lawyer or if it's a judge, judicial hearing officer, referee, or magistrate. So this is one of the reasons why I'm giving you this information, because, like I say, I run into a lot of individuals in my job as court advocate, and then over my many years of being a court advocate, who have had a lot of issues with the court, but those issues were based off of a false doctrine. And it was because that false doctrine exists because they had a lack of knowledge of what the judge's job really is and what the attorney's job really was. And so this is why I am trying to get this information out there to you, and so that you can know what this is, and you can better get into court and be able to represent yourself pro se. I also want to talk about this too. A lot of times individuals wind up representing themselves pro se because of the financial burden that the court system can put on you sometimes. We find ourselves in divorces, visitation and custody disputes, and the cost for these legal fees can be astronomical because, some of these cases can go on for several months. Some of them because of their reoccurring issues. You can find yourself back there fighting over the same issues over and over and again. And I know there's a lot of you who could attest to this. You found yourself pretty destitute, out of a job because of your many court appearances and not being able to afford to pay for an attorney. And therefore, you see yourself applying for a public defender and in certain cases making too much money to qualify for a public defender and therefore find yourselves representing yourself pro se. You also, those who find yourself in that position where you make a little bit more or more than what is the required amount to get a public defender or state appointed attorney, you can file under what is called an Article 722B application. Now that falls up under the Family Law Act, Article 722B. What that does, it allows you to receive a attorney appointed by the court, but after your case is completed, you will pay an amount for that specific attorney. Now that amount will be a fraction of what you pay for an actual attorney, but if you qualify under a 722B, you can receive legal representation that may help you, litigate your case if you just can't afford an attorney on your own. You make a little bit too much to get a public defender, and you just don't think you're in the state of mind to litigate your case on your own. So what you would do is go to that referee or magistrate, or not magistrate, or maybe a magistrate, but go to that referee, judge, judicial hearing officer or magistrate, and just basically say, I am applied for a public defender, you didn't qualify, and you have to make the request to the judge to apply under a 722B application. And that'll help you as far as being able to get some representation for yourself. Okay? So remember that, 722B. And so one of the things, like I said, we do at the American Judicial Rights Organization is that we help individuals to be able to maneuver through that court system through our TV shows like this, through informational shows like the one I just gave you, or the one we're videotaping now, and the many shows that we have done in the past. And our goal is to make sure that you're informed so that you will know how to function and maneuver through that court system. Pretty soon, we will be opening up our organizational membership to individuals out there who may want to join an organization that is all about reforming the family court system. Pretty soon, we will have our website up, and in future shows that will be posted. We will also post our telephone number in the website as well, and all information. Also, you'll be able to view our shows that we have videotaped in the past or in the present on that website as well. So all of the information will be on that website. But we will be pretty soon accepting members. We will be pretty soon acquiring space where we could be able to have these meetings and be able to build membership for this organization. And our goals is simple. Our goals is to make sure that the public and politicians are aware of the state of the family court system. We want to make sure that the courts are fair, just, protect the rights of the individuals in the court system as well. We want to make sure that certain legislation, if necessary, is passed in Albany so that we could have a structured, fair court system bylaw. We want to make sure that there is an equality for the mothers and fathers who struggle in that court system on a regular basis to be in their child's life. Because the most important thing to us is the structured environment of the child and the family unit as well. And that whole aspect, in my opinion, is not really a priority in the family court system because it is structured to be so confrontational. And there's usually negative outcomes when you have a confrontational system because you usually have a winner, you have a loser, you have individuals who are not satisfied with the outcome. Tempers begin to flare and hostilities linger between the two parties who are put at odds with each other and are really at the focus middle of that whole confrontational court system. And so that's what we do at our organization. We want to make sure we protect those rights of the parents, and we want to make sure that mediation and negotiation is at the forefront of any individuals that go through that court system. And that is a main point of our court advocacy program. You know, one of the things I do is I make sure that if the individuals can settle their difference outside of the court system, then please take the necessary steps to do that, because the court system, family court system, is very confrontational, and you may find yourself, you know, at odds in a very bad way with the individuals who you are in confrontation with, be that the father having this confrontational issue with the mother with the father, mother and father against grandparents. You know, all these things are issues that we take into context, and our goal is to strengthen the family unit, even though you guys have made a choice to separate and go your own ways. So what I want to do now is just recap some of the things that we have discussed today. And one of them is starting with the history of the family court. This is a very old court. It's been here since the late 60s. You have your judicial hearing officers, once again, that was appointed. First one in the 70s here in New York State. In the 80s, that system was fully structured. You have your referees, your JHOs, which is your judicial hearing officers. You want to make sure that you understand the powers that these individuals have to hear and determine, which is make the final decisions in your case, or to hear and report, which means they hear all of the issues in your case and submit those final reported issues to a judge, and the judge makes the decision. The CPLR rules that are important, which is CPLR Rule 2104, CPLR Rule 4311, CPLR Rule 4317. These are the CPLR rules, which you can find in the Civil Procedure Law. These books are right down in the your public law library here on East Avenue. And these are the rules that govern the power of the referee and his legal obligation to hear and report on your case if the referee stipulation is not signed by the parties and his limitation of power if that referee stipulation is not signed. And remember, it has to be signed by both parties too. If one party decides to sign it and you did not sign it, the judicial hearing officer or referee only has the power to hear and report. All parties must sign the referee stipulation. So if one party signs and you say you're the petitioner and the respondent signs and you decide not to sign, it's still set at a hear and report status for the referee. The referee can only take it to a hear and determine, which means the referee makes the final decisions in your case if all parties agree and sign. That is the parties in the case and their lawyers as well. So the referee has to make you aware of these rights. And once again, the referee has to tell you when giving you that referee stipulation to both parties and the attorneys, the referee has to say, what I have given you is a referee stipulation to sign. What it means if you sign that referee stipulation is I will have the power, which will be given to you by me by signing, to hear and make all determinations in this case. Now, if you decide not to sign, which is your legal right, then I will have the power only to hear and report my findings to a judge. Is it okay that I hear and determine, make the decisions in your case? This is what the referee basically, in a nutshell, has to explain to you, because that referee stipulation is a contract. And a contract is only valid if full disclosure is made of what the contract that you are signing entails. And so the referee has to fully disclose this to you and your attorney. All of you involved has to understand this. And I think this is the most important issue that I have discussed in this show, because I want individuals to understand this, because we have people right now who have had decisions made in their cases, and the referee stipulations involved in that case have not been signed according to the rules in CPLR Rule 2104, which goes into the details of how the referee is supposed to get the permission of the petitioner and the respondent and their attorneys to hear and determine in these cases. And if you, after hearing this show, was not told any of these things, my suggestion to you is to file a complaint, especially if you are dissatisfied with the decision made by the referee or the judicial hearing officer in your cases, especially if you do not like how they're handling your case so far and you are in front of them. Some of you may find yourself in front of them right now, and you know for a fact that you were not told you're right. My suggestion to you is to, make sure that your right is protected in this way. So that'll be basically the gist of the educational show today. Once again, my name is Joe Lewis, and you have been watching Justice Now, coming to you from Public Access Television, the People's Network. Thanks for tuning in, and remember, in future shows, we will be posting all information about the organization, how to become a member of the American Judicial Rights Organization, and meeting times and places for individuals who are interested in doing that, and even becoming board members on our board. All this information will be posted in future shows. And so be looking forward to that in the future. Once again, you've been watching Justice Now, coming to you from Public Access Television, the People's Network. Thanks for tuning in. Until we meet again, may God bless you.